And what we thought at the time made the most sense, and which Damon Seligson set forth at the first hearing in September, is that it makes sense that all of these parties and all these claims all come into one action. We take discovery together, we try one case together. And there's a lot of very detailed practical reasons for that I think all make sense. And so, as we told the court we would, we filed a motion, we served a motion on all the parties, including on the proposed new parties, including the Alberts, including the McCabe's, the state police, the town of Canton, and we got oppositions back. And the process in Massachusetts is such that you don't file the motion right away, but you serve the motion, you get the oppositions in response, and then you take the oppositions and the motion and you file it all at once. But there's a nick in that rule that says, if when you get the oppositions, that you want to withdraw the motion because that makes the most sense after you flesh this issue out, then you can withdraw the motion. So once we got the oppositions here in this case, we were persuaded. We were persuaded that adding all of the parties in one action, at least at the beginning, may be more cumbersome than helpful. And so what we did is we told the parties, we're not going to file this motion. Instead, we're going to file a separate action. And that really has to do with the fact that all these new parties
changed their mind.
Have raised the concept that they have potential pre-discovery motions to file and or other procedural maneuvers to make, and all of which would happen before discovery. And so it occurred to us that it made more sense that those motions and whatever procedural maneuver has to happen in one action, and that we continue with the wrongful death case separate, so it doesn't get slowed down, separate, but that after we vet the claims and the parties in this separate action, which we filed in Bristol County just this week, which is the complaint that you talked about at the opening here, Billy. Once we get all the parties and the claims settled, that we consolidate everything, at least before trial. Because trying this case multiple times makes no sense to anybody. And if there's one thing we can agree on, it's not much here. I think everybody can agree on there should be one trial here. The notion that we multiple trials with the prospect of...
I'm not an attorney, but even from a legal standpoint, I could understand how they would want things separate. Again, as Alan Jackson said, this is going to make more work. They're already going to depose and have interrogatories from both sides. Why do it twice? I understand that side of the argument. So to me, either way, it doesn't matter. If you want to get it done and knock it out this way, fine. From the legalese side of it, I'll let the attorneys handle it. To me, it makes sense, though.